Welcome, liberty lovers, friends of individual rights, and fans of limited government. Pacific Legal Foundation attorney and member of the Real Justice League, Tim Snowball here with another great video on an important subject that any supporter of the Constitution is going to be interested in. I am talking about the greatest single threat to individual liberty, Franklin Delano Roosevelt. Just kidding, but he was terrible. So what is the greatest threat to liberty? This video is about the administrative state. Now, one of the primary ways that Thomas Jefferson justified the split from Great Britain in the Declaration of Independence was King George III's empowerment of bureaucrats to harass our people and eat out their substance. If Jefferson were still alive, he would probably be working with us at Pacific Legal Foundation. Now, you probably remember this from 7th grade social sciences class. Congress is vested with the power to make the laws, the President is vested with the power to enforce the laws, and the Supreme Court is vested with the power to decide the constitutionality of the laws. This essential principle is known as the separation of powers, and for many of the Founding Fathers, it was one of the most important protections built into the Constitution. And for roughly the first 150 years of the American Republic, this carefully crafted system operated mostly as intended. But for FDR and the other New Dealers, the Founders' views on the purpose of government was hopelessly outdated. Rather than a guarantee of the liberty of each individual, the Constitution's carefully crafted system of checks and balances, designed to require broad consensus and impede rash lawmaking, were seen as an impediment to progress. And instead of the Constitution being binding law based upon fixed and unchanging principles, the Progressives' goal was to transform the Constitution into a flexible, living document that could be adapted to their own political preferences. Because the most accomplished, learned political philosophers of the 18th century didn't really know that much about politics. For the Progressives, the natural rights theories of the Founders were incompatible impediments to the government-driven progress they wished to achieve at any cost. And I mean any cost. According to the progressive historian Carl Becker, to ask whether the natural rights philosophy of the Declaration of Independence is true or false is essentially a meaningless question. In 1920, Charles Merriam, he of dictionary fame, wrote that the idea that men possess inherent and inalienable rights of a political or quasi-political character, which are independent of the state, has generally been given up. Finally, John Dewey, the progressive father of modern educational theory, once wrote that liberalism is committed to the idea of historic relativity. It knows that the content of the individual and freedom change with time. Thus, the natural rights-based political science of the Founders, in which government exists to secure the natural rights of the people, was traded for rights as the gift of arbitrary and unlimited government. Our founding documents became nothing more than aged parchment comprising mere suggestions, nothing more than historical curiosities. The way legal theorist Randy Barnett puts it, we went from rights come first, government comes second, to government comes first, and then rights come from the government. Because the country was founded on the idea that people in positions of power know best and are always to be trusted, right? And how did the Progressives propose to fix the Constitution? By centralizing power in a new authority, what has become known as the administrative state. This unelected fourth branch of government would not be constrained by either the Constitution or the people. The idea was to avoid getting bogged down in all these outdated notions of democracy and the rule of law, whatever that is. Never mind that slowing things down and gaining consensus was the entire point. Progressives fought to bypass this carefully crafted and hard-won framework, instead empowering unelected experts, because experts have never led anyone astray. Bureaucrats are empowered to enact, enforce, and rule on policies imposed directly on the American people. After FDR, add in some poorly drafted legislation and one or two badly decided decisions by the Supreme Court, and you have the behemoth that is the modern administrative state. Maybe an example of how a typical administrative agency functions based on the work of constitutional scholar Gary Lawson will be useful. Here's how the separation of powers works in the modern administrative state. The Commission promulgates substantive rules of conduct. The Commission then considers whether to authorize investigations into whether the Commission's rules have been violated. If the Commission authorizes an investigation, the investigation is conducted by the Commission, which reports its findings to the Commission. If the Commission thinks that the Commission's findings warrant an enforcement action, the Commission issues the complaint. The Commission's complaint that a Commission rule has been violated is then prosecuted by the Commission and adjudicated by the Commission. This Commission adjudication can either take place before the full Commission or before a semi-autonomous Commission administrative law judge. If the commission chooses to adjudicate before an administrative law judge rather than the full commission, and the decision is adverse to the commission can appeal to the commission. If the commission ultimately finds a violation, then and only then, the affected private party can appeal to a bona fide Article III court. But the agency decision, even before an actual court, possesses a very strong presumption of correctness on both matters of fact and of law. Now, besides this blatantly unconstitutional mix of powers, there's also the sheer size of the administrative state to consider. There are now so many administrative agencies controlling the food we eat, the water we drink, the cars we drive, the products we purchase, and nearly every aspect of American life. We aren't even sure how many agencies actually exist. The original purpose of many federal regulatory agencies was probably well-intentioned, such as ensuring safe food, drugs, or working conditions. I say probably because I'm reminded of Thomas Sowell's saying that the welfare state is not really about the welfare of the masses. It's about the egos of the elites. Evidently, Kanye likes this quote too. I'm reminded of a quote by a great American named Tim Snowball. The road to hell is paved with government interventions. But regardless of the need for such regulations or the merit of any particular program, they still must be developed, implemented, and enforced in a constitutional manner. The size, scope, and power of the modern administrative state has far surpassed even the worst imaginings of the Founding Fathers. An explosion of government power unprecedented in modern history, resulting in individual rights violations and the rule of law replaced by the rule of bureaucrats. Now, given everything that's happened, some of you may be wondering whether there's any hope of enacting meaningful change. Well, I'm here to tell you that there is. Since 1973, Pacific Legal Foundation has become one of the most active and successful public interest legal organizations in the United States. Every day, we stand opposed to every government attempt to violate the separation of powers contained in the Constitution and protections guaranteed in the Bill of Rights. In total, Pacific Legal Foundation has argued 11 cases before the United States Supreme Court, 4 in the last 10 years alone. Now, that's an impressive number for any legal organization, but it's even more impressive given that we have achieved victories on behalf of our clients and the rest of the country in 9 out of those 11 cases. And this number does not even begin to scratch the surface of the many, many victories we have achieved at all levels of state and federal courts across the country. This year, we also launched our Center for the Separation of Powers, which will lead in the development and promotion of solutions to end the administrative state. This year, we also did something unprecedented, not just for ourselves, but also for the wider legal community. We filed 2 multi-state initiatives specifically aimed squarely at reining in the power of the administrative state. And we are just getting started. Hey Liberty lovers, I'm here outside the Real Justice League headquarters. I wanted to thank you so much for watching the video. I really appreciate it. If you liked it, if you hated it, if there's anything you'd like to see in the future, please leave us a comment below. For now, keep fighting.